So good morning, everyone, and welcome to those in attendance at this remote meeting of the local review body of Aberdeen City Council. Please note this meeting will be recorded and published online for public access after the meeting. You're also reminded to note that we may have members of the public or press observing today's proceedings. Can I ask those who are observing today's meeting to keep their microphones and cameras switched off throughout? Can members of the local review body leave their cameras on but mute their microphone when not speaking? As the local review body contains quasi-judicial business, members are reminded that they should not leave the meeting during consideration of any of these reviews. This meeting has been convened in response to 3 requests for a review of the decision taken by the appointed officer under the Council's scheme of delegation. Members of the local review body will have before them copies of the review documents as listed in the notice calling the meeting. For information, Councillor Cook will join us after the first review as he cannot participate given the location within the electoral ward, and that will be that one there. We are expecting one further councillor, but we'll bring her in to the second review if she joins in, as we will start the first one. We'll now ask Mr. Masson, Assistant Clerk, to outline a procedure to be followed in the conduct of these reviews and take a roll call of all members present. Mr. Masson.
Thank you. Members have the procedure note which was circulated with the meeting papers and is intended to set out the wider framework within which the review process operates. The first task for the review body is to come to a decision on whether the review documents contain sufficient information for the case to be determined without further procedure, and by that it is meant without further information or representations. The regulations governing the local review process require that all matters which the applicant intends to raise in the review must be set out in or accompany the notice of review. The focus of the review should be on the basis of what was before the appointed officer when a decision was made, and only in exceptional circumstances will new or additional matters be permitted to be taken into account. The circumstances in which additional matters can be taken into account are set out in the legislation and will be addressed by the LRB's advisors where relevant. This review should take the form of a structured discussion led by the chairperson to consider the matter set out in the notice of review before you, and I will conclude by drawing your attention in particular to points 10 to 12 of the procedure note. Thank you. Just in terms of attendance, we have obviously got Councillor McRae as chairing the meeting, Councillor Bolton and Councillor Copeland. Councillor Cook, can you switch off your microphone because you won't be participating? Sorry, your microphone and your camera, please, because you're not participating today. So we have got 3 members in attendance for the first one. Councillor Thacker hasn't joined us as yet, but obviously now that we've started the first one, she won't be able to participate for that. She won't be, if she does come in, she won't be able to participate for reviews 2 and 3 in any case, Councillor McRae, because those 2 are in her ward. So I'm just taking it that she won't be in attendance today. Over to you.
Thank you very much. So turning to consideration of the first review in respect of the decision to refuse the application for the change of use of lower ground floor to short-term let accommodation with maximum occupancy of 4 people at 5 Westfield Terrace, Aberdeen, AB 252RU, which is planning reference 231206. We'll now hear from the planning advisor in attendance, Ms. Lucy Green, who will provide us with a brief description of the application proposal, a reminder of why the reasons the application was refused. I point out today that Ms. Green's attendance to today's meeting is to provide us with necessary professional planning guidance because she's not been involved in the early consideration of any of the reviews on today's papers. Ms. Green will not however, be asked to express any view on the merits of proposed development, and in effect her role will be a neutral one involving the provision of factual information and guidance only. Ms. Green, over to you.
Thank you, convener, and morning, members. So I've shared my presentation.
Sorry, can I stop?
Sorry, that's the wrong one. Yes. Just one moment. Okay. So this review relates to an application for change of use of the lower ground floor to short-term let accommodation at 5 Westfield Place, and the review was submitted within the timescale. The applicant has indicated that there were no new matters within the submissions. However, there were 2 supporting letters from parties that hadn't made representations.
Sorry, can I interrupt you, Lucy?
Yes.
You're saying it's Westfield Place. The papers we got said Westfield Terrace. Can you confirm it is Westfield Place?
It should be Terrace.
Yes, it's Westfield Terrace, sorry.
It's Terrace. Okay,
Yeah.
thank you.
Sorry about that. Yes, there were 2 letters of support within the submissions. So we'll come back to that for members to decide whether to take those into account in terms of the test for new matters. So I'll continue to provide some background to the case before handing back to members to decide how to proceed. So that's the location plan showing the property on Westfield Terrace, just there. And the site lies close to the city centre and within the Rosemount area. So that's an overhead showing the house there. And it's the lower ground floor that's the subject of this application. Just some 3D images from Street View. So it's the lower ground floor, which you can't really see in that image. That's the entrance to the remainder of the property there with the front garden. So the lower ground floor is accessed around the side of the house from the back garden. That's just showing the front of the property with the garden that would be used by the remainder of the house. And that's the floor plan showing the entrance from the rear garden, 2 bedrooms. And then there's an existing staircase up to the remainder of the house. So in terms of the checklist that's submitted with applications, the maximum occupancy would be 4 within the 2 bedrooms. Lengths of stay would be a minimum of 2 days with no maximum. There would be 1 parking permit provided for on-street parking. It would be used on a permanent basis. There would be check-in from 4 o'clock with keys in a key box. Cleaning would be after each day with waste going into the house bins. There's no shared communal access into the property. And in terms of garden, the STL would have access to the rear garden, which would not be communal. There are no other short-term lets in the property, and it's been used as an Airbnb for the last 3 years. So in terms of the decision on the application, it was considered that the short-term let would have an adverse impact on the residential amenity of the upper floor residential dwelling due to the loss of sense of security and privacy afforded to the occupiers of that dwelling, and so that it would be in conflict with policy 30 on tourism and culture and policy 14 on design in NPF 4 and policy H1 on residential areas, D1 on design and D2 on amenity in the local development plan. So it was also considered that as the applicant is the current owner and resident of the upper storey dwelling, it would intend to be the owner and operator of the short-term let and the lower ground floor level. It was stated that there would be a conflict between the uses which would arise if the owner were no longer to reside within the upper storey dwelling, and if the short-term let would be operated independently of the resident in that dwelling. So the case officer had looked at applying a legal agreement or a planning condition to restrict the occupation or ownership of the two uses to ensure that they were linked together. But it was found that that wouldn't be reasonable approach to take. So the reason for refusal states that there was no option but to refuse planning permission. So in terms of the applicant's case, that can be summarised as follows. The property would remain one house with the existing staircase giving access between. There would be no material impact on the character of the conservation area. There were queries about the relevance of Policy 14 design, in particular the reference to women's safety and improving mental and physical health, and in particular safe and welcoming routes, for example, passive surveillance. It was also queried whether there would be a perceived impact on safety and security as the applicant is the resident of the upper dwelling. It was also queried whether there would be disturbance from noise transfer as the applicant is the resident of the upper storey, and that it was unnecessary to block up the door. It states that the neighbours at number 3 and 7 and 7A are undisturbed and are supportive of the application. The Airbnb is stated as being required to help the applicant pay for a care home for his mother. And it's further stated that if the property was sold, it would be sold as one dwelling, a residential house. That there are no tensions with policy VC2 on tourism and culture, and that the application could be approved with a 5-year permission. So just before I move on to the slide which considers new matters, I'll cover consultations. So the waste team were consulted and had no objection. Guests can use the residential bins until a commercial collection is established. In terms of the roads team, there was no objection. Parking is restricted as the site's within a controlled parking zone, and there was no comment from the community council, which was Queen's Cross and Harlaw. There were no representations on the planning application, the original planning application. So in a moment I'll hand back to the convener and members to decide how to proceed. And just before I do that, there's a reminder of the tests for new matters. The new matters in this case are the 2 letters of support, which were in the submissions for the LRB, but weren't in the original application. The Airbnb reviews were not considered new information as those are available online. So in terms of the tests for new matters shouldn't be raised at LRB stage, and the tests are that the matter could not have been raised before this time, or that it not being raised before this time was a consequence of exceptional circumstances. So the question for the LRB is the LRB satisfied that the new matters raised in the notice of review should be taken into account given the tests? So I'll hand back to members to decide how to proceed.
Thanks very much. So in terms of the consideration of the new matters and in relation to the test, do we feel that we need to include these new matters into our decision making, or if these matters could have been submitted ahead of time before we got to the LRB stage? I'll quickly, Councillor Bolton.
I was just going to say, yeah, they could have been raised beforehand. I don't think they meet the test, so I would think that we should be taking them at the LRB personally.
Thank you very much. Councillor Copeland.
Yeah, I agree.
Yeah, I would agree with that as well. So at the moment, we won't be taking those into consideration. Ms. Green, do we have anything further to consider at this time? Or are we happy to move further on?
It's the consideration of how to proceed.
Yeah, perfect. Thank you. So back to us, members. We now need to consider whether we have sufficient information in front of us to take a decision on today's application. Members, reminder, if you do not feel you have sufficient information to take a decision, we can request further written information to be provided. Here needs to be arranged or a site visit to be undertaken. At the moment, I feel we have sufficient information to proceed, but we'll quickly go around the room. Councillor Copeland.
Agreed.
Councillor Bolton.
Yeah, I'd agree. We've got enough information. Thank you.
Thank you very much. So as members feel that they have sufficient information to proceed, we'll now pass back to Ms. Green, who will take us through the relevant policies and considerations for its review.
Thank you. I'll just share my slides again. So it's consideration of the policies within the NPF4 to start with. Policies 1, 2 and 3 are relevant to all applications, and in considering these, members may wish to note that this is an application for change of use only, and the likely magnitude of any impact on the climate, crises, biodiversity and nature. Oops, sorry, I've just flicked that onto the next slide. Policy 13 on sustainable transport states that developments should be accessible by public transport and active travel. Policy 14 on design, the most relevant area of that is relates to creating a welcoming environment where people feel safe and the perceived sense of security. And policy 30 on tourism, I will turn to on the next slide. So this is the policy on tourism, and this section B states that proposals for tourism related development will take into account contributions made to the local economy, compatibility with the surrounding area, impacts on communities, for example, provision of homes, opportunities for sustainable travel, access for disabled people, measures to minimise carbon emissions, and opportunities to provide access to the natural environment. In particular, section E for this, of relevance for this application, development proposals for the reuse of existing buildings for short-term holiday letting will not be supported where the proposal would result in an unacceptable impact on local amenity or the character of a neighbourhood or area, or the loss of residential accommodation where such loss is not outweighed by the local economic benefits. So moving on to the local development plan policies, the site lies within a residential area under policy H1, which we'll look at in more detail on the next slide. In terms of policy D2 on amenity, that in particular covers privacy and sort of disturbance, creating a suitable residential amenity. Policy D1 is similar to the design policy in NPF4 and covers safety and security. Policy R5 on waste management seeks to ensure that there are adequate provision for waste within developments. Policy VC2 I will just move on to in a moment. T2 on sustainable transport looks at developments in terms of accessibility by public transport and active travel, and T3 looks at suitable levels of parking. The APG on short-term lets covers when permission is needed, the information needed to assess amenity impacts of proposals, and those details have been provided in the application. So I'll just move on to policy H1 for residential areas, which states that within these areas, proposals for non-residential use, which would include an STL, will be supported where they're considered complementary to residential use, or it can be demonstrated that the use would not conflict with the enjoyment of existing residential amenity. And then policy VC2 on tourism proposals for new facilities capable of strengthening the appeal and attraction of the city to a wide range of visitors will be supported. Proposals should complement existing visitor facilities and be sequentially located in the city centre, unless activity and locality-specific issues demonstrate that is impracticable. So in terms of the considerations, in particular on amenity, relevant considerations would be comings and goings of visitors and cleaners, noise from customer activities, disturbance to privacy, and perceived impact on security from the use of communal areas, if any, by transient visitors, numbers of visitors using the flat, and communal areas. So I'll just also cover the Scottish Government's publication on short-term lets, which states that they make an important contribution to the tourist economy through providing unique experiences through a host's local knowledge, offering an alternative to hotels and hostels, helping tourists that may be on a lower budget, and also providing for additional accommodation at periods of high demand. And it was found that the most common positive impact of short-term lets is local economic impact. And the circular on short-term lets refers to Policy 30 on tourism, which I've covered. It states that these considerations should be balanced against wider policy objectives, and it states that planning authorities may grant permission for a limited time. So a reminder of the primacy of the development plan policies, with all applications being determined in accordance with the plan unless material considerations indicate otherwise, and each application being treated on its merits. So for this particular application, it lies within a residential area H1, so impact on residential amenity, which is covered by the various policies I've listed there. Appropriateness of the location for a short-term let, and the impact on the local economy. So does the proposal comply with the development plan as a whole, or are there material considerations which would indicate otherwise? And I'm happy to answer any questions.
Thank you very much. Any questions, members? Councillor Bolton.
Yeah, sorry. You said that it's been operated as an Airbnb since 2020. Do we have any evidence of that?
I mean, on the Airbnb website, you can see there's a large number of reviews going back in time.
Okay, so there is a level of evidence. In terms of in the description, it was saying that there'd be no building, modern, etc. And you've gone back a number of years. In terms of safety of the property, clearly, I'm sure it probably is, but in terms of not having permission to have converted it as such, is that something that we should be concerned about?
I mean, the case officer considers that to have a short-term let in the lower ground floor would create a separate planning unit. So there'll be two, the upper floor and the lower floor. And this application is just for the change of use, so it wouldn't achieve that. But, you know, that they could come back with a further permission or a certificate of lawfulness, and they could obviously apply for a building warrant as well. So it doesn't prevent the granting of this permission, should members wish to do that.
Okay, and my final question, excuse me, was you mentioned that they were trying to reach a sort of a legal agreement. Can you just remind me what exactly that was going to be again? But they felt it wasn't reasonable.
I think what was being sought was that the ownership would be tied between the lower ground floor and the upper floor, so that you couldn't have a situation where the occupier of the upper floor wasn't in control of what was happening on the lower floor. It was found to be unreasonable. As things stand, the ownership, it's all one because of the staircase in between.
Okay. No, it's just the two different elements. If there's not the appropriate planning in place, and then we're giving a change of use, I just want to make sure that from a kind of a safety point of view, and if the occupier then maybe chose to sell the bottom part by dividing it, it's just to understand the implications of having the short-term let separate to the house. But I'm just working out how we can do that. I know that we've talked about time limited, that we've done quite on a number of them. So it was just, maybe if you can think about that while some other people ask some questions. Thank you.
Thank you very much. Councillor Copeland.
Yeah, thanks, Convener. My understanding of this, and Lucy, you might be able to correct me, there has been no alterations to this building whatsoever. It's simply that the lower ground floor has been let out on an Airbnb basis, but there has been no alterations to the building whatsoever. And this is basically to formalise what was in a previous arrangement since the change in law. Is that right?
Yes. When you say no alterations, the staircase between the two still exists. That I don't know if there have been any other alterations, but yeah, that link still remains.
So basically, we're looking at, there's a door either at the top or the bottom which can be opened, but there's no physical alteration being made to the building. Is that right?
Yeah, that's my understanding. Yeah.
Okay, and it's been operating for probably 3 years as an Airbnb, yeah?
Yes.
Okay, thank you.
Thank you very much. I don't really have any further questions at this time. I don't know if others do, Councillor Bolton or Councillor Copeland.
No, I'm fine.
I think that the question that Councillor Copeland, that's what I was trying to get to, because I couldn't understand why we were asking about planning approvals and looking back to see if there'd been anything, if there wasn't something had changed. So that's where the confusion was. I was thinking, have they altered it? That it would require this planning warrant or whatever, building warrant, but you're saying it's not.
If they were to, separate the two such that you could sell them separately. So, I mean, at the moment it's one property. Yeah. So if someone, I guess if you tried to sell the lower floor, it would come up in a solicitor's search that it's part of another property. So what the case officer was saying is that in their view, they were creating a separate planning unit, which should have a separate permission. There should be a permission to separate the two, but that's not what this application is.
And that's not, as you say, it's not what's been suggested. So that's helpful.
Yeah.
Thank you.
It's almost to me as if a property were to have an adjacent or an enclosed granny flat, and the granny flat's being let out as an STL, but it's still contained within the wider context of that one unit. That's what I'm getting from this. Would that be a correct assumption? Yeah.
Can I just go back in? So we're looking at number 5, not 5A. It's all number 5.
Mm-hmm.
Yes.
Perfect. Thanks very much. If there's no further questions, members, we'll move to determination on this one. So, in accordance with the procedural note circulated, the local review body will now discuss and decide the manner in which the review is to proceed. I would highlight that all representations relating to the case are being considered and taken into account. Determination, members. I'm relatively comfortable with the fact that this has been operating for the past few years. There hasn't really been much noise, complaints, etc. come through with that, and the fact that we do have an owner and operator who is directly linked to the property as well. We don't have somebody who's living away abroad from it. We've got somebody directly there who's managing that, and we'll be able to keep an eye on that. In terms of the connection to that property. I understand, like Councillor Bolton was alluding to earlier, we time limit to a lot of this properties anyway, and we can sort of kind of can control that. So if the owner was to move out, that property would then lapse. And like Ms. Green has noted as well on that if the building was to be sold, the building is as a complete unit. So therefore, if the owner was to move away, that license would probably fall away anyway. At the end of the time limitation, but also that somebody couldn't purchase that one unit that comes as that whole house there. I don't know if anyone else wants to really come in on that, Councillor Bolton or Councillor Gopin.
Yeah, just to say, so we're going to do the 5-year kind of time limit that we've done in the past, and obviously if they sell it beforehand, then we're saying that it'll probably lapse anyway. But is that what you're proposing?
That's what I propose. Obviously, we can go to a 5-year. We can reduce that time down to a 3-year if we wanted to. Just the 5 years normally what we tend to go for with any sort of STL, but it is up to ourselves if we want to shorten that time limit or it's really how we want to go on that one.
Yeah. I mean, I'm comfortable as long as we've got at least the 5-year, because if they, as you say, if they move out, the chances are they can't sell it separately because without a further planning application. So I'm comfortable. And again, it's more the fact that it's actually been operating as an Airbnb that's probably swung it. If it hadn't been that, I might have thought slightly differently, but no, I'm happy on that basis.
Okay. Councillor Copeland?
Yeah, I'm quite happy with that. As you said, Councillor Bolton, in fact, it's been operating without a problem for the last 3 years.
Yeah.
I've got a technical question for Lucy. Owners can surrender their licence any time, can't they? Even if we put a time limit on it, they can surrender it at any time before that. Is that right?
Well, licensing is not my particular expertise, but I imagine that you can. I can't imagine you'd be forced to keep it open.
Yeah. Okay. No, I'm quite happy to grant with the 5 years.
Okay. Perfect. So, Ms. Christie.
Sorry, it was taking a while for my camera to go on their convener. It was just to say, if you do put a duration time limit onto this permission, the planner was saying that was against it wouldn't be appropriate because it was against the immunity, and I think that was the argument there. And maybe Lucy could let us know, but that's what I read. I got from it. So as long as the members feel that there's material considerations that override that. This is what I say. I'm sure it was immunity the planner was speaking about in relation to a duration condition.
Was that in connection with the tying the ownership?
No, not the ownership. It was he does mention a duration condition, and he says that it's not appropriate because of the immunity of the the adverse immunity impact. So as long as members feel that there's other material considerations that would override that. Sure, I think that's what I got from the report.
That was my understanding.
Oh right.
Sorry.
Sorry,
I mean,
that's
I think the two things are just getting slightly muddled. Lucy might be able to elaborate.
Yeah.
What did you say? Thank you. Sorry.
Shall I come in? I think it's just what we covered in the looking at the reason for refusal that obviously the case officer had concerns about amenity, but as members feel it's been running okay as a Airbnb, then you can attach the 5-year consent condition, and it would revert back to one dwelling after that period if they didn't apply for a further permission.
Thank you.
Okay, thanks very much for clarification on that one. So are members happy to agree what we've agreed?
Yes.
Yes.
Perfect. So as a local review body has therefore agreed to overturn the decision of the appointed officer, we need to consider whether there is any further conditions that we should attach to the approval of the application. I'm happy with how it is at the moment with the 5 year. Are members otherwise minded anything on that ones?
I'm happy with that.
Agreed.
Ms. Green, do you have any further conditions you want to bring into this one?
No.
Perfect. Thank you very much. Please note a decision notice from today's meeting will be issued to the applicant or agent in the forthcoming days. Okay, I think we'll welcome back Councillor Cook, who has been patiently waiting in the side wings for the further last two reviews. Welcome back.
Thank you.
You just want to test? There we go. We can hear you as well, Grant. So turning to consideration of the second review in respect of a decision to refuse the application for change of use to of a flat to short-term let accommodation with maximum occupancy of 2 people at 24 Picardy Court, Rose Street, Aberdeen, AB10 1UG, planning reference 240985. Again, we'll pass back to the planning advisor attendant, Ms. Lucy Green, who will take us through a brief description of the application proposal and a reminder of the reasons why the application was refused. Ms. Green, over to you.
Thank you, convener. Share my presentation. Okay, so request for review against refusal of the application under delegated powers for a short-term let at 24 Picardy Court. And the applicant indicated on the notice of review that there were no new matters in the review submissions. However, there is a new matter which I'll provide details of in a moment, and that's a letter from the upper floor resident. In terms of the procedure by which the review would be conducted, the applicant expressed the view that the review may proceed on the basis of the information submitted. So I'll provide some more background information before handing back for members to decide how to proceed. So this is the location of the property, Rose Street here, and access taken underneath this pend into the car park. And then this is the block in which the ground floor flat is located. That's overhead photograph of it, and the flat is in here on the ground floor. So it's within a block of 3, this one being on the ground floor, and then there are 2 above. The flat at first floor level also has permission to be used as a short-term let. And the adjacent block contains 7 flats. The submissions also state that the guests would be working at the theatre, or those are that's the customer base that's being sought by the applicant. This is a 1-bed flat of 44.2 metres squared. The application noted that the flat would be available for 2 guests. And in terms of the checklist, occupancy would be for a maximum of 2 within 1 bedroom. Length of stay would be a minimum of 2 days with a maximum of 2 weeks. There would be 1 car parking space. It would be let on a permanent basis. The whole property would be let to 1 group. In terms of check-in and out, the applicant hopes to meet all the guests and would undertake the cleaning themselves. There's a communal access with 2 other flats on upper floors, and there's no access to a garden. In terms of other properties in short-term let, although the checklist states that there are none known, it's noted in the submissions that the first floor flat has planning permission, which was granted in 2023, and there's been no retrospective use. So the reasons for decision really related to the fact that this would be the second of the 3 flats within the block to be used as a short-term let, which it was considered would have a harmful effect on the amenity of the remaining property in mainstream residential use. from the loss of residential character within the internal communal area and a cumulative level of activity from comings and goings of multiple short-term lets, as well as a high concentration of unknown guests within the block. And the proposed use would therefore be contrary to policy H1 on residential areas in the local development plan, policy 30 on tourism, and in particular paragraph E of NPF 4. For the applicant's case, this can be summarised as follows. The flats on the ground floor, which would minimise disturbance and noise. Sorry about the typo there. The nature of the short-term let with two guests at a maximum and targeted at performing arts means that parties would be less likely. The applicant is committed to having measures in place to minimise disturbance, and there would be less disturbance compared to students or a family, as the guests would be out working in the daytime. In terms of security, the applicant would meet guests and there would be a lockbox which would have its code changed regularly. The owner lives 10 minutes away and would be responsible for maintenance and condition, and the resident of the top floor mainstream flat has submitted a letter, which is the new matter I was referring to. So before we look at the tests again for new matters, I'll just mention consultations with the waste team having no objection. The roads team also had no objection with parking requirements being the same as a mainstream flat. The site's within a controlled parking zone, so the roads considered there would be no possibility of indiscriminate parking. The City Centre Community Council had no comments, and there were 3 letters of support to the original application, raising the points that the flat's on the ground floor, so there would be no disturbance to other residents. There would be private parking, which would avoid traffic congestion, that shops and cafes in the area would benefit, and guests would have to follow rules and conditions. So in terms of the new matter, just a reminder of the tests. So could the matter have been raised before this time, or if it wasn't raised, were there exceptional circumstances? And the question for LRB, is the LRB satisfied that the new matters raised in the notice of review should be taken into account? So I will now hand back to members to consider the new matter and also how to proceed in terms of whether we proceed today or there's a site visit, etc.
Thank you very much, members. So first we need to decide on the additional information. How do members wish to proceed?
I don't think it could have been put in earlier, put it that way. I don't think we should take it.
Okay, Councillor Cook.
Yeah, I'm kind of minded to agree with Councillor Copeland. Excuse me. Presumably, there would have been. Excuse me. Yeah, presumably there would have been neighbour notification anyway. So the only question I've got is, were there exceptional circumstances? For example, the resident in the top floor flat was in hospital or something. If we've got exceptional circumstances, maybe we should look at it. But if we've got no evidence of exceptional circumstances, I'm thinking, no, we shouldn't take it into account.
There was no evidence that I saw.
No, yeah, I don't see anything that would sort of lean towards that. Councillor Bolton.
I'm happy not to take it, given that there was an opportunity to put in within the notice period.
Yep, I would agree with that. So we won't be taking the additional into account for this one. Okay, so we now need to consider whether we have sufficient information to proceed. So members, remind, if you don't feel have sufficient information on this to take a decision, we can request that further written information be provided, hearings be arranged, or a site visit to be undertaken. At the moment, I feel with the information we've got, I'm satisfied to proceed. Councillor Bolton.
I'm happy to go with the information we have. Thank you.
Thank you very much. Councillor Copeland.
Agreed.
Thank you. Councillor Cook.
Me too.
Thank you. As members feel we have sufficient information to proceed, we'll now pass back to Ms. Green, who will take us through the relevant policies and considerations for this review.
Thank you, Convener. I'll share my screen again. So turning first to the policies in NPF 4, as I said in the last review, the policies 1, 2 and 3 are relevant to all applications, and all decisions should give significant weight to the climate crisis. In terms of policy 13, this states that developments should be accessible by public transport and active travel, and we'll move on to policy 30 on tourism on the next slide. So section B covers some of the considerations for tourism related development, and of most relevance is section E, which covers reuse of existing buildings for short-term holiday lets, and it states that those won't be supported where the proposal would result in unacceptable impact on local amenity or the character of a neighbourhood or area, or the loss of residential accommodation where such loss is not outweighed by local economic benefits. And the local development plan policies, again, the site zoned within a residential area, and I'll move on to that policy on my next slide. Policy D2 seeks adequate levels of privacy and also a sense of security. Policy R5 states that developments must ensure suitable refuse storage facilities. T2 covers sustainable means of transport, and T3 adequate parking. And then the requirements for the information requirements for short-term lets, which have been provided in the application. So policy H1 for residential areas. Proposals for non-residential use will be supported where they are complementary to residential use and cause no conflict or nuisance to residential amenity. And then policy VC2 focuses proposals on being sequentially located in the city centre or on sites allocated for that use, unless specific issues demonstrate that that's impracticable. So as I mentioned previously, the sorts of issues that can be taken into account in terms of amenity might be the comings and goings of visitors and cleaners, noise from customer activities, disturbance to privacy and perceived impact on security from the use of communal areas by transient visitors, the numbers of visitors using the flat and its location within the building, including communal areas. So as I mentioned previously, the benefits of short-term lets, the main impacts of them are on the local economy with unique tourist experiences through the host's local knowledge. They can provide accommodation in places not served by hotels and hostels, and they can provide for different budgets and also provide for greater demand during particular events. And the most common positive impact is on the local economic associated with tourism. And then the circular seeks to balance the various policy objectives, including on tourism, and states that planning authorities may grant permission for a limited time. And as before, all applications should be determined in accordance with the development plan unless material considerations indicate otherwise, with each application treated on its merits. So the basis for this decision, the proposal lies within a residential area where residential amenity is a relevant consideration. The appropriateness of the location for a short-term let and the impact on a local economy. So does the proposal comply with the development plan as a whole, or other material considerations indicating otherwise? and I'm happy to answer any questions.
Thank you very much. Any questions, members? Councillor Bolton.
I think you said, Lucy, there was 7 flats in this sort of block, but there was 3 on this one side. Is that correct?
Yeah, there's 3 accessed from this this communal stairway, and then the attached block has 7 flats.
Okay, so there's just 3. Okay, so can I just check if the ground floor is 24 and it's saying there's already a let on 25, and we've had an email from 26 supporting it, is that the correct numbering that I'm looking at?
The first floor one is the one with permission for the short-term let.
Yeah.
So that must be 25.
Yeah.
I'm not sure of the numbers, to be honest, but the upper floor flat was the new matter.
It's just
letter.
Okay.
So the upper floor one is in mainstream residential use.
Okay. And that would be number 26.
I couldn't be sure about the numbers, to be honest, but yes, the upper floor one is the one in mainstream use.
Okay. All right.
Yeah. Okay.
Okay, that's fine. I don't have any other questions at the moment. Thank you.
The applicant states that the property would be mainly used by performers or people in connection with HMT. Obviously, we can't condition any of that. I'm just wondering how the applicant is seeking or getting interest in that property. I take it that's through either word of mouth through other performers or people connected with HMT, and it's not on any Airbnb or letting agencies or any websites like that. It's all connected with HMT.
I don't have any information on that.
Yeah. Okay. Okay. Any other questions, members?
Can I just ask, this is not currently in operation, is that right?
That's what's stated on the submissions, yeah.
Okay, thank you.
Councillor Cook.
Yeah, and I don't know whether Lucy can comment on this. The Scottish Government guidance refers to places, one of the criteria is places that are not already well served by hotels and hostels. But it just strikes me that there are certainly a number of hotels within the vicinity, which isn't necessarily the fact that that is the case. Would that necessarily be a deal breaker for this?
I think that was one of the benefits of STLs, is that they can be in places which aren't served by hostels, rather than saying they shouldn't double up, kind of thing.
Okay. Any further questions, members? Okay, so in accordance with the procedural note circulated, local review body will now discuss and decide the manner in which the review is to proceed. I would highlight that all representations relating to the case have been considered and taken into account. Determination, members. I'm in 2 minds about this. It's not great that we're turning over another property within the same stairwell to an STL. Therefore, we would be outweighing the sole remaining residential property on the top floor. At the same time, I know that there's been a big push on national media with regards to the pricing of hotels and things like that, which may outprice and push away performers that come to the city because that's costs that they cannot bear. And we've seen that in places like Edinburgh and Glasgow as well, where especially around areas of high tourism areas like the fringe that performers simply cannot afford to come into a city because of the high prices of hotels. Not necessarily saying that that is in effect within our city in terms of the same pricing structures, but it's just something that I am sort of conscious of, that performers may be looking for cheaper accommodation compared to the hotel offerings. So I'm kind of split on this one at the moment, but I'm happy to take into consideration what other members are coming in with.
I would agree with you, convener, and having looked at, there's a number of hotels and B&Bs not that far who once had to close because of lack of business. And we hear from the Hotel Association about the low rates that they're charging now. I remember when I was in travel a long time ago, you couldn't get a hotel for love nor money, and we were on a par with London, but we're far from that now. And I am conscious about supporting, our existing hotels. So I'm like you. I think there's affordable hotels available. And when you've got 2 out of the 3 using the same stairwell, that's on a let basis, it just concerns me a little bit for the settled tenant. And I'm happy again to see what anybody else thinks.
Councillor Cook.
This is not going to be terribly helpful because I'm similarly in 2 minds for the reasons that you two have just articulated. We have got low occupancy rates in some of our hotels as it is. I am concerned about the loss of residential accommodation. I'm more relaxed about the amenity of the top floor flat, largely because it's this one is the ground floor. I think if you had an Airbnb on the top floor of a block, and you've got people coming and going up and down the stairs, that's one thing. But if it's on the ground floor, it strikes me as not being as big an issue. So yeah, sorry, I'm in 2 minds.
Councillor Copeland.
I am of the mind to grant it, because the alternative is an empty flat. And I do think that reasonably affordable accommodation in the city centre, self-catering accommodation, which this is not that prevalent, really. I mean, if you think we're speaking about hotels, then you go to restaurants. I know it gives you more meal, but this is a self-catering accommodation with a target audience of performers at the theatre. Close to the theatre as well, and I think the benefits outweigh the sort of detractions, if you like, because the alternative to this is probably an empty flat or a flat going up for sale. This is I think it's useful to have a self-catering, reasonably priced accommodation in the city centre. And the fact that we've got another one in the block shows that we've previously agreed that this location is suitable. So I really didn't have a problem with this. I would be voting to grant it.
I think it's not about the location. I think, the location is obviously a central location and handy for particularly the target people that they're looking at. But I think it's about keeping the balance of residential versus short-term let is where I think we were struggling with partly, and detracting from. And there is a number of areas with B&Bs not that far. And there was the Holiday Inn that was on Rose Street, which I think has actually closed, and that we've got a number of Skeens apartments are 2 minutes walk from there. And if you hear from them, they're always complaining that their rates have dropped significantly. I'm not saying we shouldn't do it, but it's just to counter. I mean, what we could potentially do is do like a 2-year grant on this one to see how it works out. That way it gives the tenant the opportunity to prove that it works. Where, I mean, the last one we gave 5 years, but they had a track record of running it, and it was within their own house. This one we're looking at, 2 out of 3 people. And I mean, if you look at performing arts, it could be people coming in later at night, I don't know who the person is up above or anything. So it's just all about balance. And this is, I think, where we're all struggling. It's about maintaining the businesses that are paying a lot of business rates to be hotels in our city, and apartments in the city, versus, losing a property off the general market, which Councillor Cook mentioned. So, it's all of those sort of challenges. So, as I say, perhaps maybe putting it on a shorter time limit and seeing how it goes. I think there's a lot of flats now being put to short-term lets because they maybe haven't been able to sell them, or or they want to wait and see if the marketplace picks up. So it's a bit of a caught between the devil and the deep blue sea, but I think this is, the challenges that we're facing considering, but I do think we've got to think about the economic benefit to the city as a whole, not just to that individual property. Or so if John and Kieran are content, I would be minded to go maybe for a 2-year let or something and see how that works.
Yeah, John makes an interesting point just in relation to that topic there with this is on the ground floor, therefore in terms of amenity the top floor resident would be protected to an extent, so you wouldn't have people passing that property to get up and access. I'd be happy as long as our planning guidance is, our guide and legal are happy as well to shorten that to a 2-year, just to see how that goes, and if it works well and there's no complaints, etc., then they can come back to us and reapply for a longer period if that's the case. So we'd be relatively comfortable with that. Councillor Cook.
Yeah, that sounds like a pretty sensible suggestion to me.
Okay, Councillor Copeland.
Yeah, I'm quite happy. It's if you want the time limit to 2 years, I can live with that.
Okay, perfect. We'll just bring back Ms. Green to see if we'd be happy to do that before we move on.
Yes, you could put on a 2-year consent. So that's on the basis, is it, just to make sure I get the wording right, that it's sort of looking at the balance between mainstream residential and short-term lets within the area.
I think that would be correct, yeah.
And the impact on other accommodation lets, such as hotels. So it's about that balance, economic balance.
Yeah.
Okay, thank you very much. Therefore, I think we're all in agreement. So therefore, the local review body has therefore agreed to overturn the decision of the appointing officer. We now to consider whether any further conditions should be attached with approval of application. I think we've covered it with the 2-year on there. Is there any other conditions that members or Ms. Green would be wanted to put onto that one? No, I think we're all quite content. Okay, thank you very much, members. The decision notice will be sent out in the next couple of days to the applicant or agent. So, turning to consideration of the third review in respect of the decision to refuse the application for a change of use flat to short-term let accommodation with maximum occupancy of 6 people at flat 5, 17 Northfield Place, Aberdeen, AB251SA, planning reference 241057. Again, we'll hear from Ms. Green, who will take us through the application and a reminder of the reasons why the application was refused.
Thank you. I'll just share my screen. Okay, so this one is request for a review for, again, a change of use of a flat to a short-term let with maximum occupancy of 6 people at flat 5, 17 Northfield Place. And the applicant indicated on the notice that there are no new matters raised in the review. However, the applicant has stated on the notice of review that they would seek a 3-person occupancy. However, the application was determined on the basis of 6, and so that's the basis for the review. The applicant submitted a new checklist, which is new information, and so in terms of the procedure, that should be considered in terms of the tests for new information. In terms of procedure for conducting the review, the applicant expressed the view that we could proceed on the basis of the information submitted. So I'll provide some background to the case before handing back for members to decide on the new information and also how to proceed. So this is the location of the application on Northfield Place. It's Aberdeen Grammar School just there. The site obviously lies close to the city centre, and that's the property there. It's a traditional tenement. And here we are, the 3D Google image of the property, just here, number 17. And the application relates to a 2nd floor flat within a 4-storey tenement. It contains 7 flats, and the building has 2 flats per floor except for the 2nd floor, where there is just this 1 flat that's the subject of the application, and it's a 3-bed flat. And the case officer report states that the other flats are thought to be all 1 beds in mainstream use. So that's the rear elevation of it, just there. And it's the 2nd floor. Layout plan, 3 bedrooms and a large kitchen, dining, living area. So as I mentioned, the application noted that the flat would be available for 6 guests. Moving on to the checklist that was submitted with the original planning application, it states that the occupancy would be for a maximum of 6 within 3 bedrooms in 5 beds. The length of stay would be a minimum of 2 days and with no maximum. Car parking would be available on street. The property would be in a short-term let on a permanent basis. It would be, the whole property would be let to a group rather than individual rooms. Check in and out would be check in but after 3 and check out before 10 with keys in a lockbox. And cleaning would be after each group or twice monthly. Communal access would be shared with 6 other flats, and there would be access to the garden. States that there are no other short the building and there's no retrospective use. Thought I'd lost contact there for a moment. Right, so looking at the reasons for the decision, there was a concern that the comings and goings from the use of the property by up to 6 transient guests and the cleaners would intensify unacceptably the use of the property over and above what would be expected of it as a permanent residence, and that would be to the detriment of the amenity of the occupiers of other properties in the building in terms of noise transmission, movement within the building, the use of the garden and a sense of security. The size of the 3-bedroom flat compared to the remaining 1-bed flats would result in the proposed short-term let impacting on the quiet residential character of the block and worsening the amenity impacts of the neighbouring flats, so that the proposal doesn't comply with policy 30 on tourism in NPF 4 policy H1 on residential areas in the local development plan. So the applicant's case can be summarised as follows. So in order to address concerns about disturbance, they did state they wished to reduce it to 3 guests. But as I mentioned, that's on the basis, the application was considered on the basis of the 6 guests. Mainstream use could result in more people living in the flat, the applicant states. It's also stated that concerns about noise and disturbance can be addressed by having strict guest policies, including quiet hours and limits on visitors. The applicant was also committed to putting measures in place to minimise disturbance. Pointed out that the short-term let would contribute to the diversity of accommodation and support the local economy, and also that this would provide high-quality accommodation in a central area, and that the flat was empty before the applicant bought it and refurbished it. So before looking at the test for new matters, the consultations are from the waste team. There was no objection. The guests can use residential bins until commercial collection is established. There was no objection from the roads team, as parking would be the same as for mainstream use. The site's very accessible and it's within a cold controlled parking zone. There were no comments from the community council and there were no representations. So just in terms of consideration of the new matters, which would include the new checklist, could that matter have been raised at the time of the application, or were there exceptional circumstances? So is the LRB satisfied that the new measures raised in the notice of review should be taken into account? So I'll hand back to members to make a decision on those 2 matters.
Thank you very much. In relation to the new matter that has been raised with the potential, the listing and the potential reduction to 3, as we're discussing an application of 6, if there was to be a reduction to 3, that would need to be a new application. Would that be correct?
Yes.
Okay. Members want to contribute at this point?
I personally don't think we should be taking in, because it's basically affecting the determination that the conditions that the planning officer used. So, you know, we wouldn't be comparing eggs with eggs or apples with apples.
I absolutely agree. That's why I got that additional clarification point there, just to make sure we're all on the same page there. Councillor Copeland.
I am 100% with you on that one. The planning officer assessed it on 6. We should be doing the same.
Perfect. Councillor Cope.
You want to make that unanimous?
Perfect. Thanks very much. Great. So therefore, we need to consider whether we have sufficient information in front of us today to take a decision on the application. Members, reminder, if you don't feel have sufficient information, we can request further written information be provided, hearings to be arranged, or a site visit to be undertaken. At the moment, I'm content to proceed on the information that we have got. I'm seeing nodding. Councillor Copeland. Yep, nodding. Perfect. Thanks very much. Therefore, we'll hand back to Ms. Green, who will take us through the relevant policies and considerations for this review.
Thank you, members. I'll just show my screen again. Okay, so these are similar policies from NPF4 to the previous cases, with climate change being given significant weight in all decisions, and policy 13 stating that developments should be accessible by public transport and active travel. And I'll move on to the policy on tourism. So obviously there are the criteria within section B that relate to tourism related uses, and of most relevance section E, which relates to holiday lets not being supported where there is an unacceptable impact on local amenity or the loss of residential accommodation wouldn't be outweighed by local economic benefits. And then local development plan policies. Again, the site falls into an area zoned under policy H1, and I'll move on to that on the next slide. Waste management facilities should be provided in accordance with policy R5. I'll move on to policy RC2 on the next slide. Sustainable travel and parking are similar to the policies within NPF4, and also the information submitted has been compliant with the short-term lets APG. So residential policies, a reminder that for non-residential uses, they should be considered complementary to residential use in accordance with the policy, or it can be demonstrated that there will be no conflict or nuisance to residential amenity. And then policy VC2, the sequential location in relation to the city centre, and the appeal in terms of the city and supporting a wide range of visitor attractions. So the relevant considerations in terms of policy H1 on residential amenity would be comings and goings of visitors and cleaners, noise from customer activities, disturbance to privacy and perceived impact on security from the use of communal areas by transient visitors. The numbers of visitors using the flat and the location within the building are also considerations. And then we're aware of the Scottish Government's publication on short-term lets, which highlights the contributions to the tourist economy through the host's local knowledge, potential to provide accommodation in places not served by hotels and hostels, providing for a range of budgets with affordable accommodation, and also for times of high demand. And the main positive impact of short-term lets being on the local economy. With the circular, a reminder of balancing wider policy objectives when considering short-term lets and the ability to grant permission for limited times. And in evaluation, the primacy of the development plan with all decisions being taken in accordance with that unless material considerations indicate otherwise. So again, the basis for this decision would be the residential areas policy and policy 30 on tourism, the impact on residential amenity, the appropriateness of the location for a short-term let, and the impact on the local economy. So does the proposal comply with the development plan as a whole, or are there material considerations outweighing that? And I'm happy to answer any questions.
Thank you very much. Any questions, members? Not seeing any hands at this time. Okay. So therefore, well, let's go on. So therefore, in accordance with the procedure note circulated, the local review body will now discuss and decide on the manner in which the review is to proceed, would highlight that all representations related to the case have been considered and taken into account. Determination, members. At the moment, I'm content with what our officer has put forward in terms of the application. I feel that the number of residents within this block in terms of the amenity of their residents is unacceptable in terms of the intensity of users. Therefore, at the moment, I think I would be upholding the officer's recommendations, but we'll go around the room. Councillor Bolton.
I would agree with you, convener, and I think the fact that they're now submitting things like checklists and offering up fewer people, I don't think it's been thought through as thoroughly as I'd like. And I do still have concerns with the comings of going of 6 people on a communal stairwell when it's in the second floor. So, to protect the immunity, I would agree with yourself to uphold the officer's recommendation.
Thank you very much, Councillor Cook.
I completely agree with the two of you for exactly the same reasons.
Thank you very much. And Councillor Copeland.
That's unanimous.
That's great. Thank you very much. Therefore, the local review body has therefore agreed to unanimously uphold the decision of the appointed officer, and the application is therefore refused. Please note a decision of today's notice will be sent out to the applicant or agent in the forthcoming days. Thank you very much, member. That brings us to the end of today's meeting. Thank you much for all your forbearance, and enjoy the rest of your day.
Thank you.
Thank you.
Thank you.
Thank you.
Thank
Bye.
you. Cheerio.
Right.
Bye.
See you later. See you later.